Morning, everybody. It's really nice to see all of you, if only virtually. We're doing a number of events with the Planning Advisory Service for officers from local authorities, but I'm delighted that we've got a good audience of councillors here today because we are proposing some quite significant changes to national planning policy that will bear both on the preparation of plans and on development management decisions. Now, as Martin says, there's a couple of presentations. There's quite a lot of material in here because of the extent to which we're updating planning policy. So I'll try and pace it as steadily as I can and explain things as clearly as I can. But obviously, if there are any questions, very happy to pick those up after the presentations. So, as Martin said, we're consulting on what's effectively a complete rewrite of national planning policy, the national planning policy framework, which is our more or less one-stop shop for national planning policy, set out in a single document. And the first question you might ask is, well, why are we doing that? The National Planning Policy Framework, or the NPPF in shorthand, has been around since 2012 and subject to a number of changes over the years. Most recently, in December 2024, the government confirmed a number of changes to the existing framework. But the important point to stress about those is that they were by no means comprehensive. After the government was elected in the summer of 2024, it did have some immediate priorities for changes to the planning system. And those are the ones that were taken forward through the changes that were made in December of that year. But they were very partial. And we think that there are opportunities to make wider and more impactful changes to various aspects of the framework. And it's worth saying that this is not just the present government. A lot of this work and the thinking flows from thinking that was being done by the previous government as well. So there's been a long-standing ambition to present national planning policy more clearly. Currently, if you look at the National Planning Policy Framework, it's written in a sort of narrative style. And we think that's not as clear as having distinct policies of the sort that you might find in a local plan. So that's been an important objective. Secondly, an objective has been to try and make national policy more what's called rules-based, or more precise about the criteria in which it may or may not be appropriate to grant planning permission, for example. And that's to improve the consistency of decision making, the predictability of planning policy for applicants and others. We're also, though, through this process, wanting to try and make national planning policy more comprehensive. There are various aspects of planning that apply to large parts of the country, or indeed across the whole country, where currently national policy is silent, and where we think there are things that can sensibly be said at the national level, not least because that then avoids the need for those things to be repeated in local plans or other parts of the development plan, so that plans themselves can focus on more locally specific matters. And then last but not least, obviously all governments have been wanting to support growth, not least the current one. And we think there are further opportunities as well through changes that we can make to better support growth, particularly economic growth, but by no means at the expense of the environment or indeed social objectives. So we are trying to maintain a balanced approach while at the same time identifying areas where we can better support particular sectors, as I'll explain in a minute. All of those objectives flow through into a number of principles that underpin what we are proposing to do. So this was our brief, if you like, for changing the NPPF. So one thing that's important to stress at the outset is that our ministers did not want to tear up the bulk of existing national planning policy. Lots of it is very well understood, very well established, forms a core part of the work of your officers day to day, whether that's in preparing plans or making decisions on planning applications. So while we've rewritten the framework, so a lot of the detailed wording changes, what we've tried to do is maintain the gist of well understood aspects of national planning policy, while, as I say, setting things out more clearly where we can in the form of discrete policies. There has, of course, been some updating that's been necessary in a few places, and we've also tried to plug some of those gaps that I will explain more fully in a minute. Equally, though, we're not trying to do everything in here. The government fully recognises that there are many aspects of planning where policy is best made at the local level because circumstances vary between different authorities. So there's a division here between what we're trying to do at the national level to cover generic issues and all of those important issues that remain for decision at the local level. And then the final principle was that it was important that we reflect the new legal architecture for plan making that is being introduced as a consequence of the Levelling Up and Regeneration Act that was passed under the previous government and the Planning and Infrastructure Act that has recently been passed under the present government, because those put in place new arrangements for plan making, more or less at all levels, including, of course, the new system of spatial development strategies across the country. So where necessary, it's important that we update planning policy to reflect that new architecture. It's worth highlighting the really big changes at the outset. So, as I say, a lot has stayed the same, but there are important changes. So the first really important change that you'll notice if you look at the proposed text is that decision-making and plan-making policies have been clearly separated into two parts, albeit that those parts remain within topic-based chapters. So currently, if you look at the framework, you can dip into any particular chapter, for example, on transport or minerals, and much of the text talks simultaneously about plan making and decision making without really doing enough to distinguish between the principles that apply in those different situations. So we've tried to pull that apart so that you've got clear policies if you're producing plans of different sorts, and then separately, if you're making decisions on planning applications, there are specific policies that you can see on planning decisions as well. That is still retained within topic-based chapters. So you will still find, for example, a chapter on transport, but within that, what you'll find first of all is a brief overarching objective. Then you will see policies for plan making, and then you will see policies for decision making. There's also been some reordering of the chapters within the framework. That's to do a couple of things. It's partly about emphasis and prioritization. So a chapter on climate change has been brought forward and brought together with our policies more widely on sustainable development, given the importance of that for planning policy and decisions. But we've also taken the opportunity to separate out certain matters into discrete chapters. There is a new chapter on energy and water infrastructure because those are so critical for supporting development as well as things like the transition to clean power. There's also a new chapter on pollution, public protection and security matters, again, because of the importance of those things. And it's not mentioned on this slide, but we've also brought out into one chapter all of the policies on navigating the processes for thinking about flood risk, which we know is a really important issue in many, many parts of the country, but where the policy is quite complex. So we've tried to pull that apart and simplify it so that when you or your officers are navigating those policies, it is much easier to follow, hopefully. I'll come on to this more fully later on in the second presentation, but we have tried to simplify this thing called a presumption in favour of sustainable development. That is aligned with entirely new policies on the types of development that should be acceptable in principle, both inside settlements and outside settlements. Now, I'm sure you'll have questions about those in particular, and we're going to deal with that in the second presentation today more fully. The other big change to flag is that some of the material that is currently set out in national planning guidance, which sort of hooks onto the national planning policy framework, some of that we brought into the framework itself, or are proposing to bring into the framework as annexes to it. And that's in a small number of areas where we think that guidance contains essential material for applying the policy itself. So, for example, it includes the standard method for assessing local housing need. It includes some of the tables which are essential for applying the policies on flood risk and things like that. One thing I should just point out is that none of the changes that we're consulting on now affect the nature of the standard method for assessing housing need, which was changed in December 2024. We're not proposing to change that again now. There are some tweaks to the presentation, but it's essentially the same policy. I've talked about this a little bit, but we've gone to great lengths to try and improve the presentation of national planning policy. I've talked about how we've split the policies into those for plan making and decision making. You will see that short objective at the start of each chapter. That's not meant to be a bit of policy that you use directly if you're making a decision on a planning application, for example. Those objectives are just there as overall context in terms of what the policies that follow are trying to achieve. Each of those policies has separate numbering, and that's because we know that it's been quite disruptive whenever the National Planning Policy Framework has been changed in the past. All of the paragraph numbers have changed. So if officers are trying to refer to things in an appeal statement, for example, they suddenly have to familiarise themselves with new numbering. We're hoping that by having discrete numbering for each policy, that this whole thing will be a lot more resilient to any future changes that might happen in the years to come, and can be a lot easier for you and officers to refer to. We're going to be trying to bring footnotes into policies wherever possible as well. And we're also thinking really carefully about how the usability of the final framework, once we finish the consultation, can be improved. So in particular, when you access this digitally, how can we make that as easy to use and to navigate as possible? What you'll see in the framework is there's an introductory chapter that talks about how to use the framework and what planning is there to do, the purpose of planning, if you like. And then there are a couple of chapters on procedural matters. So one on procedures for plan making and one on procedures for decision making. As I said earlier, the plan making policies need to work with the new architecture for plan making being set out through legislation. We're expecting the regulations for the new plan making system to come into force before long now. So the consultation proposals that we're consulting on anticipate that. We I've tried to set out wherever possible clear policies for the different sorts of plan that local authorities and others produce. So you'll find policies for local plans, for minerals and waste plans where applicable, for a new style of supplementary plan, for neighbourhood plans, and for spatial development strategies. We've also tried to be clear through these policies about the importance of not going beyond the key things that plans are there to do. So we're trying to encourage planning authorities to focus very much on allocating land for development, identifying areas where things need to be conserved or enhanced, things like your overall settlement strategy, and policies which are relevant to the local area. So if there are particular issues that are pertinent to the local area, policies that are relevant on those, rather than replicating or duplicating matters that we're setting out at a national level, which hopefully shouldn't be necessary given the clarity of the framework and the more comprehensive set of policies that we are proposing to introduce. Importantly, many will be familiar with the legal duty to cooperate between authorities, which has been in place for some years now, and which is now being dispensed with because there was concern that it was tripping up too many plans when it got to their examination. So instead, because cooperation between authorities clearly remains important, we are taking a more policy-based approach, a more nuanced approach, hopefully, and you'll see that among these policies as well. And last but not least, you'll see a policy in there on local standards. So these are the quantitative standards that might be set out in plans. So things like local parking standards or greenbelt standards. There are certain limits that we are proposing to impose on that, and that is particularly where those standards might cut across other regulatory regimes, in particular the building regulations, so that again we can have a more streamlined approach to standards in plans and that they work effectively with those other regimes. When it comes to decision making, again, there are a few important changes. There's more emphasis on proportionality in terms of things like pre-application engagement and the information that's required of applicants. We've also done quite a bit to strengthen, we hope, the policy in there on viability. And in essence, what we're proposing to do is place even more emphasis than now on trying to identify viability issues and resolve those at the plan making stage, because ministers are very conscious that it's not helpful when you're dealing with individual planning applications if applicants are very frequently seeking to renegotiate contributions. So the emphasis here is very much on trying to sort those issues out at the plan making stage and limit the ability for renegotiation when it comes to individual planning applications. Obviously, there is a balance to be struck there, and this is a particularly important area on which we're seeking views through the consultation. As I've said, I will talk about this a bit more fully in the second part of the session today. So we've got some really important new policies designed to direct the right development to the right location. So I'm not going to talk about that much more right now. I will skip on to the next bit. But as well as locating development in the right places, there is a wider set of policies in a separate chapter, but allied with it, on climate change considerations more broadly. What we've tried to do here is bring together much more comprehensively the various things that planning can do in terms of both climate change mitigation and adapting to its effects. So we've got a more comprehensive set of principles for plan making, the things that you can take into account, but also for decision making in relation to both mitigation and adaptation. Now, hopefully you'll be aware that many of those things that can be done are actually scattered across the different aspects of planning. So, for example, some of it relates to transport interventions and sustainable locations. Some of it relates to renewable energy development. So what these policies do, as well as bringing all those things together, is also signpost to other bits of the framework where you can find more detailed policies on those matters. One particularly important change in that chapter is that we have, as part of those policies, highlighted the importance of wildfire risks. Now, in the context of a changing climate, that is one of the risks that is fast increasing. There have been some well-publicised incidents in recent years of damage from wildfires, including to residential premises. All the forecasts are that those types of risks are likely to increase. And we've suggested in the policy some of the things that can be done to try and mitigate those risks. Now, this is a fairly new area for planning. And because of that, we are particularly keen to get feedback on whether those are the right things, whether there are other things that can be done, and so on. Moving on now to the chapters that follow, which start with a series of chapters on the different forms of development. So there is, of course, a chapter on housing. As I've said, that doesn't affect many of the things that were put in place in December 2024, including the approach to establishing local housing need. But you'll see in there that it does contain a stronger emphasis on identifying and addressing the particular needs of different groups in society, including different types of affordable housing and rural housing, and how we can deliver a wider range of types of housing across major developments in particular. There's rather more change when it comes to national planning policies for the economy. And arguably, this is one of the areas where the existing national planning policy framework says too little. We've added quite a bit into that chapter to try and recognise the importance of commercial development. So the chapter proposes that substantial weight be given to those forms of development where it would benefit business expansion. It would also give substantial weight to development that would support domestic food production and various other things. We've also added in more detailed policy on particular forms of development where particular considerations apply. So that includes freight and logistics. It also includes various rural economy uses, including agricultural development and diversification. When it comes to the high street and retail policy, we're proposing rather less change, although we are again suggesting that substantial support should be given to proposals that would support town centres, but that would also help them to diversify and, where relevant, to intensify the uses so that best use is made of land in those. One particular thing that we are asking about is what's called the sequential test. So currently in national planning policy, there is a thing called a sequential test for what are referred to as main town centre uses. So that includes uses such as retail, but also things like offices and certain other uses which are often located within town centres. And essentially the policy requires that if development for those uses is proposed outside of town centres, you ask the applicant in the first instance to consider if a town centre site is available in preference. So this is designed to reinforce the role of town centres and try and prevent them being weakened by development in out-of-town locations. That policy has been in place for many years now, but it has been weakened a few years ago by changes to the use classes order, which is secondary legislation which allows uses to change from one use to another in certain circumstances, and which has made it much easier for certain uses to change into and out of retail use, for example. So the sequential test as it stands is less potent than it used to be. It still applies to new built development, but where changes of use are proposed, it's less effective than it was. So we're asking a particular question in the consultation about how important it is to retain the sequential test, or whether this is something that's really had its day, and whether it's better to allow places to adapt and change in a rather more fluid way. So we're particularly keen to get feedback on that from your authorities. There's a number of other chapters on development of various sorts. So there's a chapter on telecommunications where there's actually been relatively limited change. But as I said before, we've also got an entirely new chapter on energy and water infrastructure that would give substantial weight to the benefits of water infrastructure development, renewable and also low carbon energy development and associated infrastructure. We've also updated the chapter that we have on minerals development. So this is particularly important for minerals and waste planning authorities. Two critical changes in here are that we are giving much stronger emphasis to what's called critical minerals and also growth minerals. So these are things that are crucial for certain industrial sectors and for the green economy, where we have some important reserves across the country, which are an important strategic asset. At the same time, we're also taking a more restrictive approach to the extraction of fossil fuels, given the wider transition to green and low carbon energy that the government is trying to pursue. Following those chapters, there's a series of chapters that are more around places and the quality of development. There's a chapter on the use of land, the effective use of land, which has been updated. It includes a number of important proposals, including stronger encouragement for plans to set minimum density requirements where that's relevant. But it also proposes specific national minimum density requirements around stations and certain other locations such as tram stops. So 40 dwellings per hectare, that's what DPH is, around all train stations, and 50 dwellings per hectare around what we've defined as well-connected stations. So those with a certain level of service and in certain travel to work areas. Very, very keen to get feedback on whether that's the right approach, whether those metrics are correct. Do let us know what you think. There are also various other policies in there which are designed in particular to help support better use of brownfield land and to allow small sites to come forward. So it supports things like higher buildings at street corners where that's appropriate, the redevelopment of plots, including residential curtilages, the land around houses, but only within certain limits, because we're very conscious of the need to avoid gardens being grabbed wholesale. And then there's also a new policy in there about residential extensions, which we know is a very, very common issue for planning authorities to deal with. On the green belt, there are relatively few changes. much of the big change here was made in December 2024 when we introduced the concept of grey belt land for land that makes a relatively limited contribution to the most important green belt purposes. But one key thing that we are proposing here is that land around those well-connected stations in the green belt, we are saying should in principle be regarded as suitable for development. That is also true, incidentally, of undeveloped land around well-connected stations outside the green belt, as I'll come to later on. Now, we know that's a really big change in policy, and we've already had quite a bit of feedback on that, and obviously we are very, very keen to know what authorities think of it. But clearly there is an opportunity there to deliver homes in relatively sustainable locations. So that's the key reason why the government is proposing that change. A chapter on design has been updated. The key change here is that policies for considering the different aspects of design have been updated. And in particular, we've updated a policy on criteria for decision making so that it aligns with national guidance on design, which is also being revamped. And I think today we are publishing updated guidance on design in draft form, which I would also encourage you to have a look at. So those two things should now work together. On the transport front, one of the things we started to introduce in December 2024 was what's called a more vision-led approach to planning. There has been a lot of criticism in recent years of what's called the predict and provide approach, whereby transport impacts are modelled, in particular increases in vehicle use arising from development, and additional road space just provided to meet that anticipated increase in vehicles. And there's been research that shows that that can become a bit of a self-fulfilling prophecy. If you provide the road space, then it almost encourages traffic generation and can erode the quality of the places that are being created. So the vision-led approach almost turns that on its head and says to applicants and to authorities, think about the sort of places that you're trying to create here and where people want to live and work. What does that then mean for the sort of transport infrastructure that's appropriate and the kind of trips that might be generated? So we've tried to embed that approach much more now in national planning policy. There will need to be more guidance to accompany that in terms of the details of what it means for things like transport assessments themselves. We've also introduced a bit more flexibility, that if you're seeking to set maximum car parking standards, and there's various other changes in there to add additional detail for you as local planning authorities on things like street design, the location of roadside facilities, ports and aviation development, and also how we can improve the rights of way network where that's affected by development. I mentioned the new chapter on pollution, public protection and security, which bundles together a range of very important issues, including things like pollution. We've tried to set out in that chapter clearer criteria that you can apply when you're considering things like that, including relevant safeguards for hazardous sites. You will also see in that chapter stronger policies to support necessary development for the purposes of national defence or other public protection purposes, for example, in relation to development that may be necessary for the Coast Guard or for essential flood risk prevention. After that, there's a chapter on healthy communities. That's also seen some changes, again, with a view to making those policies clearer. but also to emphasize the importance of making sure that developers provide community facilities where significant development is proposed. And we've also sought to strengthen the policies that are in there on the retention of key community facilities where there's a risk that those might be lost. Then, excuse me. Then towards the end of the framework, we've got some chapters on the natural and historic environment. I mentioned that we have completely redrafted the policies on flood risk to try and make those as clear as possible. But we've also strengthened policy, in particular on coastal change, given the array of risks that arise from things like coastal erosion and flood risk in many parts of the country. We have also updated and strengthened the policy on sustainable drainage systems, or SUDS, to require that those are designed in accordance with new national standards for those. On the natural environment front, we've made a number of changes. That's partly to reflect new legal requirements. So local nature recovery strategies are being rolled out across the country. We've cross-referred to those in a number of places. We've placed more emphasis as well on the role that green infrastructure and nature-based solutions generally can play in supporting development and helping to mitigate some of the effects of things like climate change. There is stronger policy on swift bricks, requiring that those are incorporated in developments wherever possible. And we've also set out more systematic policy on the different types of protected areas for nature that exist. Because you have areas that are designated because of their international importance, those that are designated because of their national importance, and also areas like local wildlife sites, which are of local importance. And currently, the framework is silent about what you should do if you have those sites of local wildlife importance. So we've tried to plug that gap by saying something about those areas. And then on the historic environment, again, a lot of redrafting, essentially with a view to doing two things. First, to set out a more structured approach to try and make it easier to work through those policies for you and your officers, but also to try and create a more positive approach to how we approach heritage assets. Clearly, these are things that are very, very important for the character of local areas. They are a national asset as well as a local asset. But equally, we don't want to hinder their sensible adaptation where pragmatic things can be done. So we've tried to put that more positive approach in place as well. There's also, again, in the spirit of gap filling, some additional bits of policy in that chapter on World Heritage Sites where those exist, on conservation areas, which will affect most if not all of you, and also archaeological assets. And then finally, there's an annex on how these changes would be brought in. So what are the transitional arrangements? Now, this varies depending on whether it's about decision making or plan making. Now, typically, where the National Planning Policy Framework has been updated in the past, it kicks in immediately for the purpose of making decisions on planning applications and appeals. And that's, again, what we are proposing in this case. So once we've been through the consultation process and we've considered all of your views and we've made any changes, it would then be finalised and it would kick in immediately for that purpose. And we're also saying that if there's then any inconsistency between the framework and pre-existing plan policies, then in most cases those plan policies that are inconsistent would be given little weight unless they've been examined and adopted against the new framework. So if you've got a very new plan where a case has been made for something that deviates from national planning policy, then there is a circumstance there in which that would continue to be given weight. For plan making purposes, it's slightly more complicated. So where plans are being brought forward under the new plan making system that we're legislating for now, then this new framework would apply. But other plans produced under previous versions of legislation would proceed in accordance with transitional arrangements that have previously been set out, most recently in December 2024. So it depends very much where you are in the plan making system as to which version of the framework would apply for plan making purposes. Now, I think that's the end of that first bit. So I'm going to pause there and hand back to you, Martin.
Thank you.
Fast forward, if people don't mind the rapid repetition of what they've just seen. Hopefully, we are back to where we should be.
Okay, brilliant. So after this next session, we'll have some more time for questions. Thank you.
Yeah, thank you, Martin. And thanks again for the questions just now. So I flagged earlier on that one of the key changes in this document, perhaps the key change, is that we're proposing to introduce new national policy on the location of development, and it also affects the so-called presumption in favour of sustainable development. So this is quite important to understand in terms of what we are proposing and how this would work. So I'm going to try and unpack that for you through a few slides. So this slide is very much a summary of what we are proposing. At the moment, national planning policy is more or less silent on what development is appropriate where. Now, it isn't entirely. So if you're an authority with Greenbelt, you may be familiar with the fact that you'll find in the national planning policy framework currently a list of the types of development that are deemed to be not inappropriate in the Greenbelt. But you won't find that for the countryside generally. And you won't find that for land within settlements generally. Although it's important to stress that one of the changes made in December 2024 was a very strong emphasis on redeveloping brownfield land where it's located within settlements. But beyond that, national policy has not really said very much, other than for a few specific types of development. So, for example, you can find national policy currently on isolated homes in the countryside and the limited circumstances in which that may be appropriate. Now, that contrasts with what many of your plans do, which is set out policies for the location of development and what might be appropriate within towns and villages and what might be appropriate in the countryside. Now, we are proposing that we adopt a similar approach at the national level. And that approach would distinguish between land within settlements and land outside settlements. And building on that approach in the current version of the NPPF, within settlements, there'd be a general presumption that development should be approved, other than in certain circumstances. And I'm going to come on to what those circumstances are in a moment, because they are really important caveats to that. Outside settlements, the approach is almost flipped on its head, because we're talking about the countryside here. So we are proposing a clear set of rules for the types of development that should be regarded as acceptable in principle in the countryside. And obviously those are much more limited. And the circumstances in which, therefore, development in those locations might be approved. So we're trying here to build on what's fairly common practice across different parts of the country, but to give that greater clarity and consistency at the national level, which is currently lacking. But there are some really important safeguards, so it's important that I talk to you about those more fully now. Now, one thing you might have in your mind at the outset is that if we're starting to talk at a national level about development inside and outside settlements, well, what is a settlement for that purpose? We have proposed a definition in the glossary to the framework, and I put it there on the screen. It's broken up slightly here from the version that you'll find in the glossary, but this is essentially the text, and I've emphasized a few bits. So it would include predominantly built up areas of different sorts, but it would also include land which is likely to be built on, which is adjoining those areas because it's been allocated in one of your plans, or it has permission for development already. So we would regard those things as part of the settlement, because eventually that's going to form part of the built development in that location. Now, we're very conscious that some local plans identify settlement boundaries where you regard something as being a settlement. Not all plans do, and where that is the case, where there are no settlement boundaries, usually there are criteria for identifying settlements. So the way these policies would work is with the settlement boundaries that you have defined, or with the criteria that you use for identifying settlements. Over time, to improve certainty in the system for everybody, our policy would encourage local plans to set settlement boundaries where you don't do that already. If there are circumstances in your plan where you don't do either of those things, where you don't have settlement boundaries or criteria, then for the time being, reliance would have to be placed on the definition that we are proposing here. So, to talk in a bit more detail about the approach inside settlements first. This is policy S4 that we are consulting on, and that would require approval of development within settlements unless, as it says there, the benefits would be substantially outweighed by adverse effects. Now, that is consistent in broad terms with the approach that you'll currently find in national policy, particularly as updated in December 2024. So it's paragraph 125C in the current national planning policy framework, which is effectively a kind of brownfield presumption. The policy that we're consulting on goes slightly beyond that, in that, in principle, it could also apply to undeveloped land within settlements. Although in reality, most of that undeveloped land would be excluded because there are some very important exemptions set out in the policy. So if development would conflict with land allocated for particular purposes in your plans, if it would conflict with areas safeguarded for particular purposes, so for example, areas of importance for nature conservation, areas that are retained as open space, then that emphasis on development is effectively switched off. And there is also a set of national policies that you'll find scattered across the framework that say that in specific circumstances, development should be refused. And I mean, I'll list those in a minute, but that's another way in which this tilt in favour of granting permission would, in practice, be switched off. As I said earlier on, outside settlements, that approach is almost stood on its head. So here, the approach is that if you're outside a settlement, basically development should be limited. But there is some development that is appropriate in the countryside, and you'll find a list in policy S5. It is very similar to the list of development which is not inappropriate in the Greenbelt, but it is appropriately a bit more relaxed because, of course, this is not the Greenbelt, this is the wider countryside. And it's important to say that these policies do not apply to Greenbelt areas. If it's development in the Greenbelt, you still need to look separately at the Greenbelt policies in the framework. So this applies to the wider countryside, which is not in the greenbelt. The other thing this policy would enable is the release of land where there's an evidence need which is not being met. So in other words, that enables development to happen, not because it's development that would generally be acceptable in the countryside, but because there's an unmet need which is not being met in some other way. And that's effectively what the existing presumption in favour of sustainable development would allow. So to give you an example, there will be circumstances where there isn't a 5-year supply of housing land. In those circumstances, the existing presumption in favour of sustainable development would allow additional land to be released outside settlements. This policy would do the same thing. There is one very important change that we are making, though, because the existing presumption would, in theory, allow that additional land to be released almost anywhere. We're making clear through the policy we're proposing now that any such development should be well related to existing settlements rather than being, anywhere in the open countryside. So that's an important change to try and steer development to the most appropriate locations. The other change in here that's important to flag, and I mentioned it earlier, is that the policy would also allow some development around well-connected stations within reasonable walking distance of that category of stations. And as I said earlier, that's a really important policy change we appreciate, and we're very keen to get feedback on the criteria that we're proposing as well as that overall approach. I mentioned the set of policies that would effectively turn off the tilt in favour of development in those various circumstances. And there's a number of them. I've listed them on the screen here. They include harm to town centre vitality and viability in certain circumstances, also things like poor design or inefficient use of land. Flood risk came up earlier on in the questions, and that's one of the other things that would turn this off, as well as significant harm to biodiversity or indeed substantial harm to heritage assets, unless there are countervailing benefits. So there are some very important caveats in there for all of this. Now, I've mentioned the presumption in favour of sustainable development that is currently in the framework and does a similar thing in many circumstances. One of our concerns about the existing presumption is that it is quite cumbersome to use and includes various terms that your officers, or indeed you, if it's a committee decision, need to unravel. So it asks you to consider what are the most relevant policies in any given case, and are those up to date? And there's been a lot of litigation around this, and it's not as clear cut as it could be. So instead of that, the tilt in favour of granting permission in various circumstances that the presumption delivers is now really embedded within these policies about the location of development. So you will still see a policy in our proposals, which is called the presumption in favour of sustainable development. But in reality, it doesn't do much more than signpost you towards those new policies on the location of development. So we've tried to make this easier to use for you and your officers, but vitally, while it still includes that tilt in favour of granting permission, it is definitely not granting permission at any cost. There are important safeguards, as I have set out. So to summarise all of this, what we're trying to do is give strong support for the principle of development within settlements, provided that is on suitable land. With then a more rules-based and predictable approach to the forms of development that are allowed outside settlements. and removing some of those ambiguous concepts like up-to-dateness of policy that you'll currently find in national policy. In many ways, what this means is that the so-called presumption in favour of sustainable development does rather more of what it says on the tin. It becomes a presumption in favour of suitably located development, the right development in the right place. So we're hopeful that while this does include this positive tilt in favour of development, it's very much a positive tilt in favour of the right development in the right place, and hopefully a much clearer policy for everyone to operate. So that is it in terms of that second part of the presentation. Martin, I'm going to hand back to you because I'm sure there will be questions about that as well as wider issues.
Yeah, thank you very much. Right, okay.